It is a derivative work.
No matter what I do to it.
Yeah, but the question is, and what we didn't get into in the session, was that for all of the bundle and all of the rights that exist, there are a lot of exceptions in the law, and fair use is one of them. And it really depends a lot on what you're doing with that work. You mentioned collage, and if you're taking, I don't want to say small because it's not just about quantity. Fair use is a difficult concept to get your arms around, and there are 4 factors we have to consider in fair use. The amount is just one of those factors, and here's an example. Gerald Ford wrote his memoirs, and a magazine scooped his book the day before it was to be published, and they only took like 300 words of the whole enormous book, which is a very tiny amount. But that was too much because it was the quality, not the quantity, because the words that they chose were the heart and soul of that book. And they were using it for the same purpose as the book, to convey that idea. And so that tiny bit was too much. On the other hand, you could take an entire portrait or an entire work of art, and if you're sufficiently transforming it, not just that you're making changes, but that you're creating something that has a different purpose from the you're not just replacing the original, you're creating something with a totally different purpose, then that can be okay. And what I'm saying to you now is not going to send you home with an answer, because the answer is you have to do a fair use analysis, and there's no simple, quick way to do that. But that's what you have to do to answer your question. The interesting question comes up is if you're taking somebody else's work and doing something else with it. And and certainly if you're creating a new work and it's obviously derivative, it is. The interesting question has come up where companies, like novelty companies, have legally purchased individual copies of works of art and physically affixed them on tiles and sold those tiles. And in court decisions, it's gone both ways. Some courts have found that that's a derivative work. Because it's serving a different purpose than what the artist intended. They bought it legally. They didn't reproduce it. They didn't violate any of your rights. Well, they may have violated number 2 as a derivative work, but they didn't reproduce it they legally purchased that copy and put that copy on a tile and sold it. Some courts said that's not okay. Other courts have said that is okay because it's just how you're choosing to display it. It's like if you put it, the tile was like a frame, and you legally owned it. And there is a concept in copyright law called the first sale doctrine, where if you buy a piece of artwork, you own the physical thing. And you can do pretty much whatever you want with that thing. You can't exercise any of the rights from the bundle of rights, but for the physical thing itself, you can sell it, or you can give it away, or you can rent it, or you can destroy it. And so these other courts that said that was okay, we're saying basically, they bought the thing, they owned the thing, they could do whatever they want with the thing. Who owns the work in those museums? Do you think it's the museum? Because usually it's not.
Well, that's what I don't know.
And that's the first question you need to ask. Okay. Like we said in the session, you have to identify what is it that you're using that is copyrightable at all. Now, if it's a statue that was created 1 million years ago, not a big problem, okay? Because copyright expires too. And it's probably not subject to copyright protection at all, in which case you don't have an issue. But if you're talking about a work that could potentially still be subject to copyright protection, then your next question has to be, who owns the copyright? And I doubt it's the museum. Sometimes there is that assignment, and it could be the museum. Not often. The copyright remains with the creator of the work, and it also gets passed down to the heirs when the copyright owner passes away, if the term hasn't yet expired. Now, you might have a contract problem with the museum. That's a different issue. The museum could impose, by contract, restrictions on what you can do in their museum. And they can absolutely say contractually, you can't take pictures in our museum. If you come in, you agree not to. That has nothing to do with copyright. That's a contract with the museum.